All right, let's see if folks can hear me through that. Good afternoon, Mr. Forte. Are you able to hear me?
Yes, Judge.
Great. Is it distant or clear enough?
It's clear enough.
Could it be louder?
It doesn't need to be louder. It's still got the echoing effect.
Okay. All right, well, we'll work on that. As long as you can hear it, I won't be doing most of the talking here. It'll be the lawyers and the clients, so we'll work through it. Well, it is the 19th. We have a jail calendar with 8 positions on it. And I'm going to see if our friends out at the jail have a particular order in which they want to go. I'm not seeing the screen that is the jail. Ms. Nelson, any insight into that?
Let me look and see.
Could end up being a very short calendar. While we're waiting to hear back from Ms. Nelson, why don't we talk about position 7, Mario Duncan?
Yes, Judge, my case, I've spoken with Ms. Hodge on this, and there is a witness that I'd like for Ms. Hodge to speak to. I think would be dispositive of the case, and we were asking, and Ms. Hodge agreed, if we could reset this to the next final plea until we can, so she can talk to this witness.
So help me understand why this comes up now and not during the many weeks that separated this case from the last time it was on the calendar.
I think Mrs. Hodge is new on the case. I think the witness was presented to the previous ADA, I believe. And when I spoke with her, she didn't know about this witness. I think she's a new ADA in this case. I think there was a previous.
Well, she's been working on Judge Reader's cases longer than I've had Judge Reader's cases. So that's a
Oh, okay. Somehow, yeah. I thought that, Melvin Dansby, I thought he had presented this witness.
Is this one of the cases, Mr. Johnson, that you took over for Mr. Dansby?
Yes, Your Honor.
Okay, all right. So that could be part of the handoff, but again, that's not the state side. So Ms. Hodge, why are we only now trying to figure out how to talk to this supposedly dispositive witness?
I just learned of it, Your Honor.
Mm-hmm.
Tell me what that means.
That means defense asked me to speak with her. I don't have, well, him or her, I don't have this person's information yet. So Mr. Johnson is going to provide that to me. When I reached out to him regarding how he wanted to proceed with the case, he made me aware that there was a witness that he would like for me to speak with. Well, he asked if I had spoken with the witness, and I said the only parties I had spoken to were the victim's mother. So he made me aware that there was someone he wanted me to speak with.
Okay, and you and Mr. Johnson had this conversation when?
Yesterday, Your Honor.
Yesterday, yeah.
Okay. And do you have the information yet, Ms. Hodge, about how to reach the witness, or Mr. Johnson's going to get it to you?
I don't have it, Your Honor.
I have it, Judge, and I have the information.
Okay, so you can get it to Ms. Hodge today?
Yes.
All right.
Matter of fact, I'll email her. I'll email her the information.
Okay. Well, let's figure out what is happening, if anything, with this calendar, because it might be that we have to do this all over again, and then we could keep this case right where it is if we aren't going to be doing this again for a couple weeks, that ought to be enough time for Ms. Hodge to at least talk with this person. That might lead to more investigation she wants to do, and then there may need to be more time. Ms. Nelson, do you have an update as to why the jail has not joined us?
I see that they were sent an email with the Zoom request. Let me reach out to Ms.
Oh, there they
Boyd.
are.
Oh,
Like 5 South just joined us.
yay.
85 South, how you doing today?
Well, we at least know they got the calendar.
At least the 5th floor did. I'm just looking at where some of these folks are. Oh, well, we'll give them a couple more minutes. So Ms. Hodge, you'll get the contact information today from Mr. Johnson, and maybe over the course of the rest of the week, you can try to contact this individual. And why don't you let Ms. Nelson and Mr. Johnson know how much more time you might need after you communicate with this person, or if we can put it right back on a final plea.
Yes, Your Honor.
So what I'm putting down here is by end of week, we'll get some kind of update of, I wasn't able to reach the person, or I did, and I'm going to need this person to sit down and talk with my investigator more. But I want to make sure we're moving Mr. Duncan's case along. And looking in Odyssey, it's not a new case. And when was the last? There was a status hearing in March. So there've been now 4+ months where nothing much has happened. And it's a little frustrating that now that we bring everyone back together, now is when things need to happen as opposed to during that time. So let Ms. Nelson know what the plan is, and we'll figure out if we pop this back on another final plea calendar right around the corner, or if we have to extend it a little bit.
Okay. And Mr.
Okay.
Johnson, you will email me that information?
Yeah, yes, I will.
Okay.
Okay.
All right.
All right. Thank you. Thank you, Judge.
You have Ms. Hodge's email address, Mr. Johnson?
Yes.
Okay. All right. Thank you both.
Okay, thank you. All right. Bye-bye.
That concludes my business. May I be excused, Your Honor?
Ma'am.
May I
Thank
be
you.
excused, Judge?
Yes, sir.
Okay, thank you, Judge.
All right. Let's try again. Hello, jail.
I'm gonna see if I can call them, Judge.
That would be great. So while we're waiting, if I go through the calendar, position 1 says it's a probation revocation. Mr. Franklin, is that yours?
Yes and no, Judge.
Okay.
So by number, yes, it is mine. We had sent an email to you a few weeks ago. This gentleman has a pending case being handled in non-complex, and they requested permission to deal with the probation revocation alongside whatever agreement they are able to reach on the CP case.
Okay.
Additionally, it was brought to my attention today that there's also a second case that he's likely going to have a revocation on because of this new set of charges. And so you had sent back some terms that you were okay with with non-complex handling the case, and he wouldn't be getting out as a result of anything we did today. So I think it just may be, as a matter of efficiency, better to let him resolve the case in non-complex and the revocation be handled per your instructions, your guidelines rather, about it during the time to take the plea. I understand the hope at this time to be that they're trying to confirm a placement in the program.
Is the other case that Mr. Bowden has with us as well, or it's with another judge?
I believe it's Judge Schwal. It is 17 SC 152776.
All right.
And it, from what I can tell from Odyssey, it looks like it played back in 2018 before Judge Schwal.
Okay, and the, what you call the CP matter, it's been indicted, and it's sitting in non-complex, or it is right now, it's just a complaint, but, yeah.
It's still just a complaint. It's still, so the number is 20 CP 190161. And I think it's one of those situations where once they reach an agreement, they will formally either allow an accusation to go forward on an accusation and waive indictment in exchange for working out the deal kind of situation.
Okay, the lawyer listed for Mr. Bowden is Elizanne Edelman. Is that a colleague of yours?
Ms. Edelman is a colleague, but Renard, R-E-N-A-R-D, Nobles is the attorney who's actually handling it.
Okay, whoever it is, you believe there is someone for whom Bowden is an active matter and they're on it. If we don't handle this today, he's not going to fall through the cracks.
That's correct. I spoke to Mr. Renard, to Mr. Nobles as we were walking to the office this morning. We happened to walk in at the same time and we talked about it in some more detail. And he, just made it clear that regardless of what we did today, he would still be held on the CP case. And we had already gone through the email channels to get your permission for non-complex to handle the revocation alongside that resolution.
Okay. All right. That seems then like what we should do. Ms. Hall, are you okay with that, or anything you want to say about Mr. Bowden?
No, Your Honor, I'm fine with that.
Okay.
Me and Mr. Frank talked about that already.
Can you say that one more time?
Oh, I'm sorry. I said the state has no problem with that, Your Honor. Me and Mr. Franklin had already about everything how it will be handled, so I'm fine with that.
Okay. All right, Ms. Nelson, what do we know about the jail?
Apparently some of the lights have gone out in the jail. I don't know. Have y'all did 1 North yet? I'm on 5 South with position number 3, but I don't know if y'all did 1 North.
Got it. We have not done 1 North, although we just took care of the first position. We don't need to see him. We can always circle back on position 2.
All right. So I'm ready to go with position number 3.
All right. Who is handling, so this is Mr. Smith?
Yes.
Great. Who's handling Mr. Smith's case for the defense?
Your Honor, that will be my case.
All right. Hello, Ms. Patel.
Hello.
So,
Judge, I'm sorry to interrupt, but can you check with the jail to see if their other inmates are being pulled? I have the jail on the phone.
I can get him now.
I have no idea whether they're pulling their inmates.
I mean, yes, oh, it looked like 1 North came. Maybe they like.
Don't go back off.
Okay, maybe they're doing it, Stephanie.
We've got
You think they're
a couple
doing it now?
more from 5, and then we've got some.
Yeah, I see them lining up, a couple.
So they just behind schedule.
Okay, well, we're able to bounce around. If you all let us know who's ready, we'll take whoever you have ready. I just need someone to communicate that to us. All right, are you Mr. Smith?
Simpson, sir. Simpson.
All right,
Gregory Simpson.
you're Gregory Sampson?
Yes, sir. Yes, sir.
All right, position 4. That's also your case, Ms. Patel.
Sir,
Is that right, Ms. Patel, that you have position 4 as well?
Let me just double check. I did not realize. No, I'm sorry. Mr. Sampson, sorry, Mr. Smith has an AKA, so I was confused for a second. Mr. Sampson, I am handling, and that is a negotiating fee.
Well, but I just noticed Mr. Smith is known as Mr. Simpson. What's your name, sir?
Gregor Isaiah Simpson.
Simpson or Sampson?
Simpson like
Yeah.
Bart Simpson.
Okay,
So
yes,
we're on position 3. Is
Correct.
he also position 4? Is that the same person?
no, Your Honor, different client.
Wow, that's a small world. So we've got a Gregory Sampson, S-A-M-P, coming up right after Gregory Simpson, S-I-M-P. Got to make sure we've got the right folks here. So the gentleman seated in front of me is here for a probation revocation in a 10-SC case. Is that your understanding, Ms. Patel?
Yes, Your Honor.
Okay, and Ms. Hall, same?
Yes, Your Honor.
All right, well, let me call up this case, 94895. I do not have a petition, so I don't know what he's being revoked for. Anyone have any information on that?
I'll see if I can pull it, Judge.
Okay, that'd be helpful. So it was a plea back in February of 2011. If I can find it in this new. Ms. Crawford, are you able to dig anything up in your system since this is a probation matter? You're on mute.
I'm sending it, Judge.
Docket number 10SC 94895. It says violation of criminal law, failed to report to probation after being released, and failed to notify officer of arrest.
Okay, what I have, do you have the petition or do we need to get it to you, Ms. Patel, as well?
I saw the petition in Odyssey. I've reviewed it.
Okay, well, it's on your screen right now too.
Thank you, Judge.
Sure, and your screen, Ms. Hall. We'll try to get this circulated next time. Mr. Simpson, we're gonna get going now. I'm sorry, I was a little bumpy there. We didn't know if you were Greg Smith or Greg Simpson, same person.
Yes, sir.
In your case, you were put on probation as part of your sentence, and there's an allegation that in March of this year, you got arrested for some new charges relating to marijuana and
Yes.
obstruction, and you got a bond, and you didn't talk to probation about the fact that you had been arrested on these new charges. So we need to work through that. I don't know where that arrest happened, Ms. Patel. Why don't you tell me if your client is acknowledging that these things happened or what? That may speed this along.
Your Honor, what we're requesting today is that this case, this revocation not be handled today, and to see if Your Honor would consider allowing the trial judge that will have Mr. Simpson's new case handle the revocation. The nature of the new arrest, I think, would require a full-blown hearing, and in the event that Mr. Simpson exercises his right to have a trial, I see it being I see it perhaps saving us a lot more time if we waited for the resolution of the new case.
So I'm looking at the pending charges, and they have a whole lot more to do than marijuana. It's armed robbery, aggravated assault. Is that the set of charges you're aware of, Ms. Patel?
Yes.
Okay. It's not exactly what the petition says, but it may well be that when we shake it all out, whatever the arrest was in March, turned out to be a case that has led to a complaint for armed robbery. So I'm confused. The CP is from June, not March. So is it possible there was a second arrest in the year 2020?
Let me flip. I believe there might be two CP cases, but I need to be sure. There is an indicted case and a CP case, and so the CP case is the one with the more serious charges.
Okay.
And
do you have the I'm sorry to interrupt. Do you have the case number for the indicted case?
Yes, it's 20 SC 175958.
Okay. Okay, that's what the arrest is all about. And so this petition actually doesn't have anything to do, it's unamended. So it relates to the charges that underlie the indictment that is in non-complex right now. It's technically an accusation, but either way, the charging document that is in non-complex is what this warrant, this probation warrant is all about. So you still have the same request of, could we just not deal with this because Mr. Simpson is not going anywhere because he has no bond on an unindicted armed robbery? Or do you want to resolve this warrant, which doesn't have anything to do with the June arrest for armed robbery?
I would still request that we wait to resolve this to see out the other two cases. It's possible that Mr. Simpson may elect his right to take him to trial, or there might be a global resolution on the table for everything to potentially resolve. And so it seems like there's quite a bit going on. And I think that, you know, should Mr. Simpson end up having a bond on the armed robbery, then I would push to have the revocation hearing heard. But at this point, it doesn't seem like we'll be getting an indictment anytime soon on that. And so I think we've got some time.
Okay. Ms. Nelson, will the warrant that issued for the probation warrant that we were here to talk about today, will that remain in effect and prevent Mr. Simpson from going anywhere until we do have a hearing?
Let me look to see, Judge. I'm not at that booking screen. Let me go back to it and I'll look and see.
Thank you. So Ms. Hall, my thought would be if Mr. Simpson and his lawyer are saying, let's hold off on this because there's something potentially much more serious in the mix, the unindicted armed robbery. And if this warrant will ensure that Mr. Simpson doesn't get released until we have a substantive conversation about it, I'm okay with delaying things. He's not going anywhere, and he frankly has a bigger fish to fry than a revocation based on a marijuana accusation that is now a case in non-complex. What do you think?
I have no objection to that, Your Honor. I agree.
Okay. Mr. Simpson, have you followed what we've been talking about? You've been very polite and quiet, but I want to make sure we're not ignoring you. Just your lawyer is appropriately doing the talking for you. Do you understand what we've been talking about?
Yes, sir.
Okay. I didn't realize you had two different cases from 2020. One of them has now been charged. It's the arrest you had in March, where you supposedly had a gun that was stolen from Tammany County Sheriff's Office. I have no idea where Tammany County Sheriff's Office is. And it's a marijuana object. That's been charged now. What has not been charged is your alleged new armed robbery, and that's not going to move right away. So. All right, Ms. Nelson, were you able to check that?
I don't see a warrant for a probation warrant. I don't see it on the system.
Okay.
I see the warrant when you bring it up, but not on the jail side. So I'm not sure why I don't see it on the jail side.
Okay, it's linked to a booking number. I don't know if that helps, but Ms. Crawford, are you able to tell if there is a warrant for Mr. Smith/Simpson?
Give me a moment, Judge. Let me check.
Okay.
It says there's two warrants, a probation felony warrant that was issued on, looks like July 1st, 2020. And another one that was issued July 1st, 2020. So they're in there twice, two active warrants, so.
Well, and the one I signed was July 1 of this year, but it's not based on that June conduct because the warrant was written up in May and then for whatever reason took a while to get to me. So I signed it on July 1. In between the May date when the CSO wrote it up and the day I signed it, this other activity occurred. That just hasn't caught up to Mr. Simpson yet on the community supervision side.
Judge,
Yes.
Crawford, I only see that one that you signed July 1st.
Okay. Well, Ms. Patel, I'm going to go along with your request, and I'm just going to make sure I'll work with Ms. Nelson and Ms. Crawford on this, that there is a warrant out there that is holding Mr. Simpson so that things don't fall through the cracks, okay? All right, Mr. Simpson, do you have any questions?
Yes, I just want to say, with the I think it was the marijuana case. I had tried to go to court for that, and the courthouse was closed down due to the coronavirus. The reason I ain't been showing up at probation. I was showing up my probation every time I had to, but you know they had closed everything down due to coronavirus, so that's why I haven't been able to report the probation. And I didn't know when the probation office back open. I guess after I got incarcerated, it was during the time when they opened the court play back up.
Okay, well, the fact that you didn't report to probation is not the fact that I think is getting people concerned. It's the charges from March, the marijuana and the supposed stolen gun, and then even more so these charges from June. And we're not gonna work through those today, and I now better understand why Ms. Patel was saying, well, there might need to be a full-blown trial, because the charges for March, it sounds like we just need a police officer saying, I stopped Mr. Simpson, he had marijuana, he had a gun that was stolen from wherever Tammany County is. But we're not doing that today. Ms. Patel will be in touch with you to let you know what's going on from our end. We don't have the marijuana case, and it would only be random luck if the armed robbery got assigned to this court. So you may have things in 3 different places, and Ms. Patel is wise to try to consolidate them all in one place. All right, Ms. Hall, anything else on Mr. Simpson?
Nothing from the state, Your Honor.
Ms. Patel?
Nothing from the defense, Your Honor.
All right, thank you.
Position number 2, Mr. Johnny Miller.
Thank you so much. All right, Ms. Patel, I've got your name on the calendar as handling Mr. Miller's case. Is that correct?
Yes, Your Honor.
Okay, and I have this down for a plea. Is it still a plea? All right, are you ready, Mr. Forte?
Yes.
Okay, at least on the courtroom end, there's sort of a funny lag, so folks just be patient as we're working through the plea. We need to make sure Mr. Forte is able to hear what everyone says. Good morning, good afternoon, Mr. Miller.
How you doing, sir?
I'm okay. How are things on 1 North?
Are they doing pretty good? All, well to be expected.
Okay. Mr. Miller, your lawyer tells me that you are prepared to enter a plea in your case today. Is that correct?
That's correct.
All right. I need to cover 2 things with you before we get started. Normally, you'd be here in court. I'd be up on the bench. You'd be sitting at a table here. Your lawyer would be right next to you. Everyone who needs to focus on your case would be here in court. But things are not normal right now, and you're out in the jail, and I'm in court, and your lawyer's in her office. I need to make sure you are comfortable proceeding remotely, meaning you're there and I'm here and your lawyer's over there. Is that okay?
That's okay with me, sir.
All right. The other thing, just as important, normally you would have your lawyer right by your side so that if you had a question or a concern, you could just turn to her and say, hey, Ms. Patel, I don't understand what the judge is saying, or wait a minute, I thought we were doing X and not Y, but your lawyer is not right next to you. There's still a way for you to talk to her, but she is not in the same room as you. Do you waive your right to have Ms. Patel right by your side?
I do.
Mr. Miller, if at any time during our conversation you need to speak privately with Ms. Patel, let me know. Wave your hand, do something, and we'll pause. I can virtually move the 2 of you into a private room where I cannot hear you, the court reporter cannot hear you, the prosecutor cannot hear you, and you 2 can speak freely. I don't think anything will come up that makes that necessary, but if it does, will you let me know?
I sure will, sir.
Great. All right. Ms. Hall is the prosecutor on your case, and she's going to put you under oath in just a moment. Once you're under oath, it's important that you answer her questions and my questions truthfully and completely. Will you do that?
I will, sir.
All right. Ms. Hall?
Thank you. Mr. Miller, can you please raise your right hand? Do you?
I'm sorry. Okay.
It's okay. It's okay. Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may lower your hand. Please state your true, correct, and legal name.
Johnny Miller.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 66 and I graduated from Carver High.
You said Carver High?
Yes, sir.
Okay, thank you.
And Mr. Miller, are you able to read, write, and understand the English language?
I am.
Do you understand that you've been charged with theft by taking felony?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to that charge? And if you plead not guilty or remain silent, you may receive a jury trial.
I do.
Have you had enough time to speak with your attorney, Ms. Patel, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
I have.
Are you satisfied with her services?
Yes, ma'am, I am.
And do you need more time to discuss this case with your attorney?
No, ma'am, I do not.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Waive for the purposes of this plea only.
Judge, are we moving forward on a copy of the indictment?
We are. I've got a copy right here. I just printed out, and I'll talk about the signatures later, but it is indeed a copy.
Thank you. Counsel, do you waive moving forward on a copy of the indictment?
We agree to moving forward on a copy of the indictment.
Thank you. Mr. Miller, have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No, ma'am.
Okay. Has your attorney advised you of the minimum and maximum sentence to the charge that you're pleading to?
Yes, ma'am.
The minimum maximum for theft by taking felony is 1 to 5 years to serve. Do you understand that this is a negotiated plea of guilty, which means the state will recommend a sentence to the court of 3 years to serve 1 year commuted to time served upon entry into drug court?
Yes, ma'am.
There's also restitution in the amount of $125 that we'll discuss more details about later, but the court does not have to accept that recommendation. The court can sentence you to the maximum on this charge, which is the 5 years to serve. Do you understand?
I do.
Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
How do you plead to the single charge of theft by taking felony in indictment number 19 SC 167885?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am. It's fully given. Yes, ma'am. It's fully given.
Do you understand that you have a limited right to appeal this guilty plea conviction?
I do.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
I do.
Thank you, Mr. Miller. Your Honor, the state is aware of several felony convictions, I'm sorry, Your Honor, dating back to 1974 through.
So I have the repeat offender notice.
Okay.
So I see 16 convictions, almost all of which are from Fulton, and many of which were maybe before you were born. So they go back to 74. The most recent two, which is what I want to focus on, were from 2014 and 2015. They are both death by shoplifting, although one of them had an ag assault in it as well. Do you have anything more current than that?
No, Your Honor, that's what I have as well.
Okay.
And Your Honor, had this case proceeded to trial, the state would have proven that on October the 29th, 2018, at 1688 Peachtree Street, Northwest Atlanta, Georgia, in Fulton County, officers were dispatched to that location in reference to a theft. When they arrived, they met with the victim, Mr. Russell Warren, who stated that he had fallen asleep while he was waiting on the train to come. And when he woke up, he noticed that his travel bag was gone. When officers investigated, they reviewed a surveillance footage that showed the defendant taking that bag. Officers observed the defendant matching the description given by the victim, as in the manager at the train station who observed the video. They were able to detain the defendant. I'm sorry, Your Honor. They were able to detain and arrest the defendant, but none of the victim's items were returned. There is earphones that the victim is requesting back, which is the value is $125. I've spoken with him about the fact that the defendant is going to drug court and may not be able to pay that back, but we do want to put it on the record and reserve the restitution in case that once drug court is over, if he gets a job and is able to pay that money back to the victim, then that can still happen.
Well, part of drug court is getting a job, so he'll be working, Mr. Miller will, while he's in drug court. He'll have some financial obligations to drug court, but beyond that, this amount of restitution, I don't think will pose a problem. If it was $10,000, we'd need to think twice because drug court's not designed to have someone with that kind of debt as part of their sentence. But I think $125 is a reasonable figure to make Mr. Warren partially whole. Okay.
Other than that, Your Honor, that is all from the state.
Got it. Ms. Crawford, do you have anything more current for Mr. Miller than that 2015 conviction?
I show that he's currently on probation for that 2015 conviction. The case number is 15 SC 133834, and he has 3 years, 1 month, and 27 days remaining.
Okay. Thank you. And that's the only open case you see?
That is correct. He has an open case in Gwinnett, but that's all for us.
He has an open, what are the charges out of Gwinnett?
Probation in Gwinnett County also for forgery, first degree.
Okay. Do we know if there's a hold for Mr. Miller?
I'm not able to see any holds.
Okay, but that's a probation warrant, or he is on probation for that forgery case out of Gwinnett. That's what you know.
That's correct.
Okay, got it. And how old is that case?
That case is 2011. 2011.
Okay, all right, that did not make it on the list of 16. So there may be one more rattling around out there. Okay, thank you very much.
You're welcome.
Ms. Patel.
Thank you, Your Honor. Before you is Mr. Miller. He has been chronically homeless for some time. He had tried St. Jude's a few years ago. I had represented him in that. And I think that drug court at this point would perhaps be the best thing for Mr. Miller, because I think what he needs is the structure and the accountability to ensure that he is remaining in the program, staying on the right track, doing everything that he needs to be doing. On top of it, he does need stable housing. He's at a point in life where he doesn't have any numbers as an emergency contact. He doesn't have any information about anybody in his life. When he was arrested, he was found sleeping in a storage facility, and the owner of the storage facility wasn't trying to press charges because, you know, they knew that he was homeless and that this is an area that he had come to stay. With regards to the incident, Your Honor, it does not appear that this footage was salvaged that would help us ascertain whether or not Mr. Miller was the one that the manager saw on the video. But I think that Mr. Miller wants to use this as an opportunity to try to get the help that I think that we both agree that he needs. Drug court has spoken to him. They have accepted him into their program. And so, you know, this is Mr. Miller's last chance to try to get his life back on track. And it seems like he is serious about it. And hopefully this resolution will work in his favor.
Do you know, Ms. Patel, how long Mr. Miller's been in custody? Because it's not been since October of 2018.
He was arrested, or at least brought to Fulton County, May 11th of 2020.
Okay, and so at a minimum, Mr. Miller's been at Rice Street from mid-May of this year till now, so 3 months.
Correct.
Okay, there was I guess there was a bench warrant issued for him in July of last year, I guess by Judge Reeder. Mr. Miller, were you brought to Rice Street from another jail, or were you arrested here in Atlanta in May of this year?
I was arrested here. I was arrested in DeKalb. Well, I was staying in a hotel and someone came in my room and the manager called the police, and I was actually arrested in Brookhaven, and they took me to DeKalb for a for this warrant that Fulton County have on me. That's all. I didn't get another charge or anything.
Okay. How long were you in DeKalb before you came to Fulton?
About 2 days, maybe 3.
Okay, not very long.
Not very long.
And Your Honor, just a little bit more info. This case, when he was initially arrested, was charged as a misdemeanor. And then so he spent 30 days in custody in 2018. They released him on bond, and then it was upgraded to felony and indicted. And so that's how he ended up in this position.
Okay, got it. Mr. Miller, are you aware when Ms. Crawford, who is with probation, mentioned a case out of Gwinnett? Does that ring a bell? Do you remember having a case out of Gwinnett?
Yes, sir, I do.
Okay. Mr. Miller, drug court is a great opportunity for folks who are ready for it. My guess is at age 66, you are ready for it. You are done going in and out of jail and struggling with the kinds of things you described. What is the substance, or what are the substances that you struggle with the most?
Crack cocaine and alcohol.
Okay, and that's been something that you've been struggling with for a few years now?
Yes, sir, it has.
Okay. Have you talked with folks about drug court? I mean, you understand that it's not a 5 minutes a day you check in. It's a little more rigorous than that.
Yeah, I have talked to one of the directors of the program, and I do understand the intensity of it.
Okay. It also requires you to stick around. You can't disappear on us. We will find you eventually, and then you may well get terminated from drug court if you walked away from it. So I need to get a sense from you as to how committed you feel you are to your recovery right now.
But Judge, you know what? You said the word when you said I am at the age of 66 and I want to turn my life around, and I do that, and I do. And I have picked up on a beautiful young lady that really want to work with me. So I'm at the age. I have no intentions of, I really want to try something different in my life.
Okay. Well, it sounds like drug court wants to give it a try. I hope that works well for you.
Thank you.
Ms. Patel, it seems like it would make sense to handle the revocation in the 15 SC case as well. I'll just wrap it into the sentence. It would not increase the sentence. Do you waive Mr. Miller's due process notice rights so we can address that?
Yes, Your Honor.
Okay. All right. Well, Mr. Miller, I find there's a factual basis for your plea. That at the Amtrak station in October of 2018, took this gentleman's bag, and he never got anything back. I also find that your plea is knowing and voluntary. Knowing means you've understood all the things we've been talking about. Is that a fair statement?
That's a fair statement, Judge.
And voluntary means no one is forcing you to enter this plea, but you've decided after consulting with Ms. Patel that it's the right way for you to move things along. Is that also true?
That is also true.
Then I'm going to accept your plea, Mr. Miller. I'm sentencing you pursuant to the Probation Options Management Act. And what that means is that when you are on probation, if you have a minor violation, like you miss a meeting with a probation officer, you have one positive drug screen, something minor, you and probation will work that out. But if it is more significant, you get arrested on new charges, something like that, then you come back before me. Mr. Miller, I'm going to sentence a little differently than what was negotiated, and that's not because I'm more upset or think that it needs to be a whole lot more severe. I want to make sure you have enough time to finish drug court. And the way the sentence was structured by your lawyer negotiating with the prosecutor, it would only leave 2 years to finish drug court. And for some folks that works, the course is usually 18 to 24 months. But there are folks who struggle a little bit up front that we want to keep working with in drug court, and it can take 25, 26 months. In other words, a little more than 2 years. But if your probation is ended, we can't keep you in drug court. What I'm going to do is sentence you to 4 years to serve 1. I'm going to reduce that 1 year to the time you've served. So that time at the cab and the time in Fulton is the time you've served. But that's going to leave us with 3 years of probation. And that is a good cushion to make sure that you, with all that you're bringing into drug court, which sounds like decades of addiction, that you'll have enough time to complete the program. I will make it a special condition that you enter into and complete drug court. And I'll also make it a condition of your probation that you pay, as you are able, $125 in restitution to Mr. Warren. You actually won't get him. Yes, ma'am.
I'm sorry. I didn't mean to interrupt. I raised my hand because I wanted to inform you while I was on vacation, Ms. Rolak received
$78 in restitution. What I was saying is you actually don't put that in Mr. Warren's hand. You give that to probation and they'll get it to Mr. Warren. Those are the only conditions that I have. Ms. Hall, any other conditions for the sentence for Mr. Miller?
No other conditions, Your Honor.
Ms. Patel?
Nothing further from us.
Mr. Miller, you have the right, if you think it's in your best interest, to withdraw your plea because the sentence I've given you is a little bit longer than what you negotiated. It was gonna be 2 years probation, and I'm making it 3 years probation for the reasons I've given. Do you need to talk to Ms. Patel about whether you want to withdraw your plea, or are you comfortable going forward?
I'm comfortable with going forward, Judge.
Okay, then that'll be your sentence. And what I'm gonna do in your other Fulton County case that's still open, 15 SC 133834, I'm gonna revoke 30 days in that. I will give you credit for time served since May, so you've already served those 30 days. I'm gonna reinstate the balance. I'm gonna add a condition to your probation in that 15 SC case that you go into drug court and finish drug court. So your 2 Fulton County cases are gonna be in drug court. My hope is that if Gwinnett, for whatever reason, wants to see you about that forgery case, we can get Gwinnett to send the Gwinnett case to drug court as well. But I don't control what other counties do. But because of these new charges and this new conviction, I'm revoking your 15 SC probation, 30 days, credit for time you've already served, and then adding the condition that you enter into and complete drug court. The last thing I've got is your indictment, Mr. Miller. If you were here in court, you would sign it. You'd sign Johnny Miller right there. Ms. Patel would sign it and Ms. Hall would sign it. But none of you is here with me. I'm all by myself with the deputy. Mr. Miller, do you authorize me to sign the indictment on your behalf?
I do, sir.
Ms. Patel?
Yes, Your Honor.
Ms. Hall?
Yes, Your Honor.
All right, Ms. Hall, anything else in Mr. Miller's case?
Nothing further in Mr. Miller's case from the state, Your Honor.
Ms. Patel?
Nothing further from defense.
Mr. Miller, I wish you luck with drug court. I am one of the 2 drug court judges, so flip a coin. You have a 50-50 chance of working with me in drug court. The other judge is Judge Krause. She is excellent. So either way, you'll have a good judge working with you. But more importantly, the staff at drug court is phenomenal, and they are there to help you work through your recovery, okay?
Thank you for your understanding, Judge.
All right, well, good luck with drug court. That's how you'll show us you're ready for change.
All right.
Judge, I need to get some information from him.
Right. So, Mr. Miller, hold on. Ms. Crawford's got a couple questions for you.
Yes, sir.
Mr. Miller, do you have an address?
2844 Two Lake Circle.
2 Lake Circle?
Yes, ma'am.
What city is that in?
It's in East College Park, Fulton County Park. Sorry. The zip code is 30334, I think.
Do you have an emergency contact person or a telephone number?
Yes, ma'am. It's Veronica Jenkins. Her number is 678-498-178.
Okay, and I'm going to give you some reporting instructions to report to probation. Even though you're in drug court, you're going to need to report to 276 Memorial Drive. The address is 276 Memorial Drive. It's Southwest Atlanta, Georgia, 3030D, excuse me. Your report date will be August the 26th at 8 a.m.
Okay, would drug court be aware of this?
Yes.
Okay, then, thank you.
You're
And
welcome.
Mr. Miller, you will not have much to do with probation while you're in drug court, but you do need to report initially to get signed up. But there is a probation officer assigned to drug court who will be your point of contact. While you're in drug court, the focus is drug court personnel. But otherwise, you should be good to go.
Okay, thank you.
All right, thank you so much.
All right.
Can I get information on position number 1? What was the outcome with him? Because we had power outage.
Yes, ma'am. His case is going to be handled on the non-complex calendar.
Okay, thank you.
You bet.
All right, I have position number 6 and 7,
Okay.
if y'all ready.
We'll roll with that. Position 6 is Mr. Baker.
Come on,
I think
Baker.
that's Mr. Franklin's case. Are you Mr. Baker?
No, that's not Mr. Baker.
Are you Mr. Duncan?
Yes, sir.
Okay, Mr. Duncan, I already chatted with your lawyers. Your lawyer, Mr. Johnson, provided the name of a witness to the prosecutor that your lawyer said was pretty important to your case. And Mr. Johnson asked that I give you and your lawyer a little more time so that the prosecutor can talk to this witness. I don't know the person's name, but it's someone that Mr. Johnson said should help the state figure out how to sort this case out. While we were waiting for the jail to come online, they had some power issues there. I talked with your lawyer who was on the call, as well as the prosecutor. So I'm giving the prosecutor to the end of this week, so a couple more days, to let me know if they got in touch with this witness and what they are going to do next. Okay?
Yes, sir.
All right. Hopefully you know what I'm talking about. I don't know this witness. It's something your lawyer said was very helpful to you. So we'll see what the prosecutor has to say. If you've got questions, reach out to Mr. Johnson, okay?
Yes, sir.
Thank you.
Thank you.
Hey, good afternoon. Are you Mr. Baker?
Yes, sir.
All right, we got the right person. All right, Mr. Franklin, this is a final plea appearance for Mr. Baker. Are we able to go forward with that, or where are we, as you understand it, procedurally with the case?
We are able to go forward with that. Excuse me. We're able to go forward. We recently had an interview completed works. And based on my last conversation with Ms. Hall, I believe we are ready to put forward a non-negotiated plea.
Okay. Ms. Hall, is that your understanding? We can take a non-negotiated plea with Mr. Baker today?
Yes, Your Honor.
Okay. Mr. Baker, a non-negotiated plea simply means that the prosecutor is going to recommend one thing and your lawyer is going to recommend a different thing. Because this is your final plea day, you'll have the right to listen to the whole thing, hear what sentence I think is appropriate, and if you are unhappy with that sentence, and it's more than what your lawyer asked for, you can back out. You can say, you know what, Judge, thanks, I'd rather go to trial. So I'm just going to make some numbers up. It could be that the prosecutor says Mr. Baker should go to jail for 2 years. And your lawyer, Mr. Franklin, says, no, he should go straight probation. If I were to say 2 years seems too much, probation seems too little, I'm gonna give you 1 year. You could think about it, talk with Mr. Franklin, and then say, you know what, no thanks, Judge, I'm ready for straight probation, but if you're gonna give me a year, I'll wait for my trial. You'll have the right to do that, and there will be no negative consequences for you. Does that make sense?
Yes, sir.
Okay. But I don't know anything about your case. I may go along with exactly what Mr. Franklin has to say. I may think the prosecutor's got it right. I may think they're both wrong and do something different. But you'll have a chance to think through that after you hear what I have to say, all right?
Yes, sir.
2 other things before we start. One, normally you'd be here in court. Your lawyer would be sitting right next to you and we'd all be in the same room. We are not. You are out there at the jail. Do you waive your presence here in court?
Judge, we're on the record yet?
I guess we should put this part on the record.
Thank you.
No problem. So let me ask this again. Mr. Baker, normally you'd be here in court. You have a right to be in court, but times are strange right now. And it's okay for us to proceed this way where you're in one place and the lawyer's in a different place, but you have to acknowledge that on the record that you're comfortable doing that. Do you waive your right to be here in court?
Yes, sir.
The other right you have is to be able to consult freely with your lawyer during the that we're taking. Mr. Franklin's not sitting right next to you, but we can arrange for the two of you to have a private conversation if you need to. Do you waive your right to have Mr. Franklin by your side during this conversation?
No, sir.
If you have any questions of Mr. Franklin, will you let me know?
No, sir.
Yes?
No, sir.
No. If you do have questions of Mr. Franklin while we're going through this, will you let me know?
Yes, sir.
Great. All right. I appreciate that. So Ms. Hall's going to put you under oath, and then we'll go forward with the plea. All right?
Yes, sir.
Thank you. Mr. Baker, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be true? I'm sorry. Do you swear or affirm the testimony you should give in the matter currently before this court should be the whole truth and nothing but the truth?
Yes, ma'am.
You can lower your hand. Please state your true, correct, and legal name.
Monte Baker.
Are you at this time under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone to school?
24 and 11th grade.
Are you able to read, write, and understand the English language?
Ma'am.
You say yes?
Yes, ma'am.
Do you understand that you've been charged with the following offenses? 1 count of burglary in the first degree, 1 count of aggravated assault with a deadly weapon, 2 counts of possession of firearm during the commission of a felony, 1 count of possession of marijuana less than an ounce, and possession of a firearm by a convicted felon.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Franklin, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
I think so.
Hey, Mr. Baker, I got a question for you. There's a lot of noise going on. Is that happening in the background there on 5 North?
Yes, it is. It's a lot of background. I'll try to get one of these doors closed.
Okay, I know you guys are scrambling. That's fine. I just wanted to make sure if it was someone else, I would try to mute it. But we're going to roll with it. We just may have to pause from time to time. All right, back to you, Ms. Hall.
Okay. Mr. Baker, did you say you needed more time to speak with your attorney?
I think so. Yes, ma'am.
Okay.
So, Mr. Baker, you want to talk with Mr. Franklin right now? Or are you okay if we go forward with the plea?
I think we can go forward with the plea.
Okay, we'll do that. But if at any time you have a question for him, let me know. Raise your hand or something. Okay?
Yes, sir.
Thank you.
Are you, Mr. Baker, are you satisfied with your attorney's services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Yes, for purposes of this plea only.
Do you waive moving forward on a copy of the indictment?
Yes.
Mr. Baker, has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
The minimum maximum for burglary in the first degree and aggravated assault is 1 to 20 years. The minimum maximum for possession of a firearm during the commission of a felony is 5 years to serve. Maximum for possession of marijuana less than 1 ounce is 12 months to serve. And for possession of a firearm by a convicted felon is 1 to 5 years to serve. Do you understand that if your guilty plea is a blind plea, also called a non-negotiated plea, the state will still make a recommendation, recommend a sentence to the court?
Can you repeat that?
I'm sorry. Do you understand if your plea is also a blind plea, which is a non-negotiated plea, that the state will still make a recommendation to the judge?
Yes, ma'am.
Have you discussed this offer with your attorney?
I can't remember.
Okay, I'll let you, the offer from the state is, so for burglary in the first degree, the state's offer is 10 to serve 1, balance on probation. For aggravated assault with a deadly weapon, 10 to serve 1, balance on probation. For possession of a firearm during the commission of a felony, 5 years suspended. For possession of marijuana less than 1 ounce, 12 months probation. And for the possession of a firearm by a convicted felon, 5 years to serve 1, balance on probation. The court does not have to accept that recommendation. The court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge. Do you understand?
Yes, ma'am.
Do you understand this plea is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Can you repeat that?
Do you understand that this plea may be used to enhance sentencing on other convictions in other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States, if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, guilty plea may affect your right to vote, your right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
No.
I'm sorry, what'd you say?
Repeat that.
I say, is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
No, ma'am.
Are you saying no or yes?
Saying
We
no.
we like to enter this for offered. I'll explain the reasons why.
Okay.
And since we're taking a pause, I do apologize, Mr. Baker and Your Honor, counsel, For the aggravated assault, I said 10 serve 1, and that was a mistake. For that one charge is 10 serve 2. Everything else is 1. I apologize.
Mr. Franklin had heard of that before, or is this the first he's hearing of that?
He has. I made the mistake and said 1. That was the only one that I changed to.
So the overall sentence that you have in mind is 2 years in custody, 8 years on probation, and then it has to be 5 years suspended following that for the gun charge.
Yes, Your Honor.
Okay. Got it.
Mr. Baker, are you pleading guilty because you have decided that it's in your best interest to do so?
No, ma'am. I'm
Did you say-
pleading, no, I said no, ma'am. I'm pleading guilty because, you know, like, I was wrong, but at the same time, you know, it's, you know, I don't know how to explain it. So, you know.
So like Mr. Baker, like we spoke about the other day, we have certain things about allegations we disagree with, but you feel it's in your best interest to try to resolve the case so we can get out.
Mhm.
Is that a yes or no?
Yes.
So
Okay.
the way we're gonna handle this then is that this is what we call, Mr. Baker, an Alford plea. Don't worry about who Alford was or all that. It basically means that you are deciding that the best thing for you to move forward is to enter a plea in this case. You aren't necessarily agreeing with everything you got charged with. You aren't necessarily agreeing that things went down the way the police or the prosecutors said they would. But you do agree that the right way for you to move forward is to enter this plea and try to put it behind you. Is that a fair statement?
Yes, yes, sir.
Okay.
So, Mr. Baker, how do you plead to the charges of 1 charge of burglary in the 1st degree, one charge of aggravated assault with a deadly weapon, 2 counts of possession of firearm during the commission of a felony, 1 count of possession of marijuana less than 1 ounce, and 1 count of possession of firearm by a convicted felon in indictment number 19 SC 173244?
I plead not guilty. How could it be two accounts of possession of a weapon in commission?
So two things, and it may be you and Mr. Franklin need to chat a little bit. The 2 counts relate to 2 different felonies. The things you just asked about is possession of a firearm in connection with a felony. And one of them is the burglary, and one of them is the aggravated assault. They're going to be sentenced in the same way, but the state, for whatever reason, decided to charge you twice with that. But what you need to figure out, Mr. Baker, is if you want to go forward with the plea or not. If you don't want to, that's okay. That's what we're learning today. In which case you would say, my plea is not guilty. But if you want to go forward, but you don't necessarily agree with everything, but that's all right, we want to go forward, then you're pleading guilty under Alford. And then the third option is you're just pleading guilty. You guys caught me, I did it, I broke into this guy's house, I had the rifle, I did these things, then you plead guilty. You don't have to do any one of them. You decide what is best for you. If you need to talk to Mr. Franklin about it a little bit, we can set that up. I need to be comfortable that you're comfortable, because at the end of our conversation, I need to find you understood what was going on. Okay?
Yes, sir.
You want to talk with Mr. Franklin a little bit, or are you ready to go forward?
I think I need to talk to Mr. Franklin a little bit.
All right, hold tight.
Sure. Hey, Mr. Franklin.
Not yet.
I think you're gonna put your birthday.
Oh, okay.
We'll talk, but I think I'm trying to talk to Ms. Hall through the phone as well. I think we are gonna be able to no prize one of the possession of firearms during.
Okay,
Count
Yes,
four.
Your Honor. The state is going to nullify count 4 of the indictment, possession of firearm during the commission of a felony.
all right. Well, that solves one of them, but I'm gonna have the two of you talk. I'm gonna send you to a breakout room.
Thank you.
So, Mr. Baker, someone's gonna need to mess with the computer in just a minute, all right?
Yes, sir.
All right, come on back when you're done.
All right.
No, bro. Sit up.
No, don't go anywhere. Excellent. All right. Do we have any of the 7th floor inmates ready? Because the lawyers are here.
Can we do position number 4? 4 north?
Got it. Are you Mr. Sampson?
Yes, sir.
All right.
Your Honor, I just wanted to say that's a plea. I'm not
Okay.
sure if you want to start another plea.
Well, my thought would be if Mr. Forte is comfortable doing it, we could get started. If he's not, we'll wait. I don't mind waiting at all. I'm just trying to use folks' time efficiently. And I know we've got people spread all over the jail. So, Mr. Forte, are you able to pivot from one case to the other? We would not get all the way through Mr. Sampson's plea before we need to take a time out and go back to Mr. Baker. Would you prefer we just wait?
We can go forward, Judge. That's fine. I can go back and forth.
Great.
Your Honor, I have 1 second because I need to pull up.
Of course. You have to pivot also.
It's this new Odyssey I'm learning.
Yeah, I'm not warming to it yet.
Okay, Your Honor, I'm ready.
All right, let me call up Mr. Sampson's case. Here it is. Okay. So, Mr. Sampson, we had earlier this afternoon a Gregory Simpson, and now we've got Gregory Sampson. Hopefully we got all the right folks. Mr. Sampson, you're charged with aggravated assault, and it looks like criminal trespass. You are ready to go forward with a plea in your case, is that right?
Yes, sir.
Okay, well, let's get this on the record. It's 19 SC 173775. And Mr. Sampson, in normal times, you'd be here in court with us, along with your lawyer and court reporter and everyone else. But you are out of jail right now because times are complicated. Do you waive your right to be here in court? And are you willing to proceed remotely?
Yes, sir.
Okay. You also have the right to have Ms. Patel, your lawyer, sitting beside you so that the two of you can confer if you have any questions about what's going on. Do you waive your right to have Ms. Patel by your side?
Say it again, sir.
Do you waive your right to have Ms. Patel present next to you while we do this plea?
I don't understand.
Okay. So you see Ms. Patel on the screen?
Yes, sir.
That's your lawyer. If we were doing this back in the good old times, Ms. Patel would be sitting right next to you. So that if you had a question, you could just lean over and say, hey, I didn't understand that. What did the judge mean by that?
Yes, sir.
You can speak privately. If you say something right now to Ms. Patel, everyone can hear it. So it's a little bit different. So we're going forward with the two of you, your lawyer and you, in different places. Are you okay with that?
Yes, sir. I'm okay with it.
All right. If you need to speak privately with Ms. Patel, we can make that happen. You just need to let me know that you've got a question for her, and I'll move you guys into a private breakout room, okay?
Yes, sir.
Great. All right. Ms. Hall's going to put you under oath, and we'll get going. But you should know we're going to need to take a time out partway through when these other folks rejoin the call, okay?
Yes, sir.
Thank you.
Mr. Sampson, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may lower your hand. Please state your true, correct, and legal name.
Gregory Lamont Sampson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
41 and I finished 12th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Your Honor, I apologize. For the record, the state is reducing count 1, which is aggravated assault, family violence, to simple assault, OCGA 16-5-20.
So this is a misdemeanor plea.
It is a misdemeanor plea, Your Honor.
Okay, thank you.
You're welcome. Mr. Sampson, do you understand that you've been charged with the following offenses? Aggravated assault, family violence being amended by the state to simple assault, and criminal trespass?
Oh, yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Patel, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
Let me talk to her just for 1 second.
Okay, well, this is the perfect time to do it because Mr. Baker has rejoined us. So what I'm going to do right now, Mr. Sampson, is move you virtually. You don't get up, you stay right there. But I'm going to move you and Ms. Patel into a breakout room so you two can have the conversation you want to have, okay?
Well, yes, sir.
Sit tight. All right, we'll see you guys back soon.
Judge McBurney, I had one quick question.
Yes, ma'am.
I want to clarify, you did say give Mr. Miller credit from May the 11th of this year?
Right, for that 30-day revocation? Yes, ma'am.
Yeah. Okay, thank you.
All right, Mr. Forte, we are going to pivot back to Mr. Baker. Let me know when you're ready.
Ready, Judge.
Ms. Hall, let me know when you're ready. You were in the middle of asking Mr. Baker some questions.
Okay, Your Honor, 1 second. Pulling back up the case now. Okay, Your Honor, I'm ready.
Okay. Mr. Baker, we're back on the record. Did you have enough time to speak with Mr. Franklin?
Sir.
Do you have any questions for me at this point?
No, sir.
You understand that the state has dismissed count 4 in your case, which is one of the 2 possession of firearm during commission of a felony charges. That count's now gone. So there's only 1 possession of a firearm during commission of a felony count. You understand that?
Yes, sir.
The question that Ms. Hall had asked you, excuse me, that prompted our break was, how do you plead to counts 1, 2, 3, 5, and 6? She actually said all the counts, but now count 4 is gone. So how do you plead to those 5 counts? And you had said not guilty, and then you and I talked a little bit about an offered plea, guilty plea, and not guilty. Are you prepared to answer that question now?
Yes, sir.
Okay, so how do you plead, Mr. Baker, to the 5 remaining counts of your indictment?
Guilty.
Okay, back to you, Ms. Hall.
Thank you. Mr. Baker, is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand you have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 12 months from today for a misdemeanor charge and 4 years from today for a felony charge to file a habeas petition challenging the voluntariness of this guilty plea.
Yes, ma'am.
Thank you, Mr. Baker. Your Honor, if this case had proceeded to trial, the state would have proven that on November the 17th, 2019 at 2972. So I'm sorry, but I can't even, okay, I think it says Arrowwood. I'm sorry. The new Odyssey is a little blurry. I think it says Arrowwood Drive, East Point, Georgia, in Fulton County, which is the most important. Mr. Baker, I'm sorry, the victim of this case, Mr. Gary Brown, he returned to his home on that particular day. He noticed that someone had been inside of his house because there was food that had been eaten on his counter. He checked the rooms of his house after getting his gun. This victim is a retired Fulton County Sheriff officer. So he proceeded to get his weapon. He went into one of the rooms in his house, his bedroom. In the closet, the defendant was hiding in there. He had a shotgun and he pointed it at the victim, Mr. Brown, who at which point, at that point, he shot the firearm that he had, one warning shot to the ground. At that point, the defendant did drop that shotgun he had, and Mr. Brown was able to detain him until he called police and police arrived. That was pretty much the end of the incident. He was taken in with no incident. I have spoken with the victim multiple times, and the main reason why the state isn't asking for a lot of time in this case is because of the victim. He is aware of criminal cases as he's been in this field for a long time. He said that what he wanted for this defendant, because he assumed that because he was eating food in his home that he may have been homeless or going through some kind of issues. So what he ultimately wanted was for him to just fix his life and get his life together. The state is still asking for 2 years for the aggravated assault due to his criminal record. He doesn't have a record in Georgia that we were able to pull up, but he does have 3 prior convictions in Florida. All 3 are from Palm Beach, Florida. All 3 convictions are from June the 10th, 2016. And the charges are grand theft from a dwelling. The second charge conviction is a burglary from a dwelling. And the third charge or conviction, I'm sorry, is another grand theft. So for those reasons, the state still decided to ask for prison time beyond what the victim asked for. But other than that, that is all from the state, Your Honor. There is no restitution in this case.
Okay, thank you for sharing that. I want to make sure I followed the situation with the guns. So Mr. Brown, former Deputy Brown, he got his own gun out of his house as he searched his house. So he's holding a pistol in his hand.
Yes.
He encounters Mr. Baker in a bedroom closet in Mr. Brown's house.
Right.
And Mr. Baker is holding a shotgun.
That's correct.
Is it Mr. Brown's shotgun, or
No,
did Mr. Baker bring the shotgun to the house?
He brought it with him.
And then here's the part that I got most confused on. Deputy Brown, retired Deputy Brown, fired the gun, or Mr. Baker fired the gun?
The victim, Mr. Brown, shot his gun, a warning shot in the ground. He just said that he didn't want to shoot the defendant, but he did have a shotgun pointing to him. So his best reaction was to just warn him and tell him to put the gun down.
And according to what you have, Mr. Baker wasn't merely holding the shotgun, but he pointed it at Mr. Brown.
Yes, so when the closet doors opened, he was pointing the gun at Mr. Brown. So when I had the conversation with the victim, he didn't tell me that when he opened the closet door, he turned and pointed at him as if he was going to shoot, but as if it was already pointing that direction when he opened the closet doors.
Okay. The indictment alleges that Mr. Baker shot at Mr. Brown. That seems to be not correct.
I also read that in the summary from the complaint room, but after I spoke with the victim and I understood what happened, it just seemed maybe it was a little confusion there as to who shot the weapon. But it's my understanding that the victim is the one who shot his gun as a warning.
Okay. So the aggravated assault would be Mr. Baker pointing the shotgun at Mr. Brown. But as far as you know, having spoken with an eyewitness, the victim, Mr. Baker didn't actually shoot the gun. It was Mr. Brown who's basically was saying, I'm serious, you need to put that gun down. And here's how serious I am. Here's a warning shot.
That is correct, Your Honor.
Got it. Okay. Thank you for sharing that.
You're welcome.
Ms. Crawford, no Georgia criminal history for Mr. Baker?
That's correct, Judge. No history found.
Okay. Mr. Franklin?
Thank you very much, Judge. So to begin, Mr. Baker has been in custody since November 17th of last year. They changed Odyssey, so I don't have the handy equipment to tell me exactly how many days that equals out to, but you know, we're essentially just around the 9-month mark. And what I can tell you is, and you may remember some of these facts as I get into them. The cases from Florida that Ms. Hall mentioned did result in prison time for Mr. Baker. I believe he served about 4 years. If that sounds about right, Mr. Baker. He served about 4 years on those cases. And by the time he was released, everything that he knew, his family, his connections had moved to Georgia. So he made his way to come stay with his mother and some of his siblings. After a short time in the home, there was some financial hardships, and essentially being the oldest, he was forced to leave. So he was, in fact, homeless, as the complaining witness, Mr. Brown, speculated, and that is the reason why Mr. Baker ended up inside the home. One of the reasons that we are entering the plea as an Alford pertains to the nature of the burglary charge. Mr. Baker, of course, you know, he is not an attorney. And as we discuss things, the first thing you think of when you think of a burglary is, hey, you know, you go in a house and you're taking something from someone. And we have to kind of go through the facts for kind of a comb to kind of understand that, you know, if you're going to someone else's home and you're taking something like a sandwich or eating some food, that still qualifies as a taking under the law, although it doesn't fit the traditional understanding of what we imagine a burglary to be. And so to the extent that the burglary charge suggests things that Mr. Baker doesn't believe adds up to a burglary in his mind, that's kind of how we get to the point of Alford on that. The second portion of why it's an Alford, and even I think in the recitation of facts by Ms. Hall, there is some question about what is exactly meant by pointing the gun at the complaining witness. So I'm not sure if it's kind of just the orientation of how he's holding the gun while he's in the closet. But when the door is open, the complaining witness interprets that the gun is being pointed, but he also says that he's able to fire into the ground. And there's no indication from the actual facts of the case that Mr. Baker made any attempt to perform actual harm to Mr. Brown, the resident of the home. So where we are in terms of our recommendation, we believe that he was definitely in possession of a weapon that he should not have had. He was definitely in a home where he should not be. He was eating food which technically qualifies as the taking that would satisfy the nature of the burglary at trial. And although there is the indictment sets out the aggravated assault in one manner, we do believe that if we had proceeded the trial and that part was, of course, disproven, that there is still a grounds for a finding of aggravated assault because of this pointing allegation. We are, and Ms. Nelson just texted me, it does add up to 275 days. We want to transition Mr. Baker from this stage where essentially all he's known for the past roughly 5 years has been life in custody. Like I said, he spent about 4 years in custody in Florida pursuant to those burglary charges. And, you know, he has the burglary here and he's been in custody 275 days. We believe that he needs to learn, have the opportunity to learn rather, how to be productive and just how to be an adult in society, because at 24 years old and having spent approximately the bulk of the past 5 years in custody, he's never really had a chance to stretch his legs in a way in which he really knows how to exist in society, right? Like he was a child and then his entire adulthood has been spent, you know, behind bars. So we sought to seek assistance of private programming. We were finally able to get someone from Georgia Works to get an interview completed over the phone. They said he did well. He was pretty excited about how the conversation went, and he was accepted. They are physically accepting people into the program now. They have a residential component. Just a second. The program lasts for anywhere between 6 months to a year. And it generally includes people who are homeless, formerly incarcerated people, veterans. And the goal is to do what we want for Mr. Baker to do, which is become self-sufficient through obtaining housing and employment. They are paid for transitional work. They work at least 30 hours a week. And other services are offered, including NA and AA. He did not get his high school diploma. They offer GED curriculums, professional counseling services, life skills classes, case management, employment services. So it's a pretty thorough, well-rounded offering. And we would be requesting a sentence of 5 to serve 1. And we asked that 1 year be commuted to the time that he served, which is 275 days. We would ask that the possession during, which has to follow, then follow on a basis of 5 years suspended. So it would be a 10 serve 1, which is what the DA has recommended on the burglary charges, except for we're asking for that 1 year to be reduced to time served at this point. And because we just tangibly view the aggravated assault as not having the same aggression or intent as I believe the DA is kind of reading it, we're asking that as opposed to the 2 years in custody, that again, he be given the 1 year reduced to time served. And, you know, let's address those criminogenic needs that have led him into this path of incarceration. You know, homelessness, lack of job opportunity, pro-social activities, lack of job opportunities are things that lead to people like Mr. Baker being in places where they are. But we have a resolution, an opportunity that resolves a lot of those things. And consequently, we believe would address those things that are most concerning to the court and to society at large.
There is a bed waiting for Mr. Baker, or we would need to keep Mr. Baker where he is until you got confirmation, and then there would be a transport order.
I know there'll be a transport order in a week or so. One, we have to figure out how the transport is done. We're doing those kind of on a case-by-case basis because of issues with the jail going along with transportation. And we weren't clear as if like there's a bed available tomorrow, but typically they have them available on a weekly basis. So we don't think there's going to be an issue with getting a transport order to your honor within the matter of a week or so, 2 weeks or so.
Okay. Mr. Baker, the shotgun that you had in your hands when Mr. Brown encountered you, where did that come from?
I found it, Judge.
Just sitting on the ground?
Yes, sir.
Say that again?
found it.
Yeah, where'd you find it?
I was walking, I want to say over, I'm not familiar with the place like that, this area, so I can't really remember the street name. So I'm not sure.
I'm not so interested in the street, but like people don't leave a shotgun lying in the middle of the road. Where was it when you found it?
In the grass.
You know what?
In the grass, like, you know, like when you walk on the sidewalk, and
yeah,
a little patch of grass on the side that's going along with you.
And when did you find it in connection with the going into this guy's house? Did you find it that same day, or had you had the shotgun for a while?
I had it for a while.
Why did you bring it to his house?
Just I had it for protection. I went to go do my laundry at the laundromat, but I kind of like went to thinking like me walking the street at night with a shotgun, you know, I'm bound to like either get in trouble or something like that. So I changed my mind and turned around to go back to where I was coming from, and I realized like, you know, that's a long walk. So I went looking for an abandoned house, you know. So I seen this house, and the house looked abandoned. So I went in the house, and I didn't see the furniture until like I got into like the living room, the front room. So as I seen it, I was like, okay, I want to leave, but like, you know, I was so tired. I was like, I don't feel like nobody's here. So I was like, I'm just gonna search the house, make sure nobody's home. Because for one, I have a shotgun. I don't want anybody saying I'm trying to harm them or anything. So I said, I'm gonna search the house. If nobody's home, you know, I'm gonna go to sleep, wake up, and leave. But you know, it ain't planned out like that. You know, my stomach got the best of me. You know, I opened the refrigerator and seen a little food. I ate a little, and as I was eating, he pulled up. You know, I panicked. I ran in the closet and had my shotgun with me. And you know, I didn't want to use it as in, like, to harm him. You know, I had it as in to protect. You know, like when he pulled his gun out on me, you know, I pulled the gun up just as in to like stop him from shooting. You know, like that's like if you find somebody in your house, your first intention is to shoot. You know, you don't know if this person is here to harm or not harm. So I had the shotgun to not harm, like I'm not able to get the word out, but you know, it's like to prevent him from shooting me. So, you know.
Okay. What's the situation with your mom now? Are you able to stay there? Is she still in Atlanta?
Yes and no.
So she's still here, but you're not able to stay there.
No, she also done lost her house. She's staying with a friend of hers. But we are now talking again. You know, I didn't ask her if she could ask her friend if I could stay with her, because you know I'm not sure how that's gonna pan out. Besides, she got kids, you know, so I didn't want to be a burden. So I was gonna like ask like my sister or somebody.
And additionally, the program has housing options, Judge. They're residential.
Right, I heard you say that. Mr. Baker, would you be willing to stay in Georgia Works housing if that's where you end up?
Sure.
Okay. All right. Do you have any questions?
No, sir.
So, Mr. Baker, I find there's a factual basis for your plea. I understand that it is partly an offered plea, which again simply means you don't agree with everything that's in the indictment, but that you've decided that it's in your best interest to go forward. I do think the state could prove its case. If it went to trial, the jury could choose to believe Mr. Brown, that you were in his house, eating his food, in his closet with a shotgun. And I think the jury, I don't know if they would, but I think they could finds you guilty of the charges that you're pleading guilty to. So I'm going to accept your plea. I also find that your plea is knowing and voluntary. Knowing means you understood the things we talked about, and then if you didn't, you spoke with Mr. Franklin about it. Is that a correct statement?
Yes, sir.
And voluntary just means that you're going forward of your own free will. You've talked to your lawyer, you've thought about it, and you've decided this is the right way to move forward. Is that also correct?
Yes, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act, which means, Mr. Baker, that for the part of your sentence that's on probation, if you have a small problem, we call it a technical problem, you and probation will work that out. But if it's a more serious situation, you get kicked out of Georgia Works, or you end up getting new charges, that'll come back to me and we'll work through it. So here is what I intend to do, Mr. Baker. Let me tell you what your sentence is going to look like, and then you can tell me if you want to go forward with things. I'm going to sentence you on counts 1 and 2 to 5 years to serve 1 year. And I will reduce that 1 year to time served, but I'm actually not going to sign your sentencing sheet for a while. I'm accepting your plea, but just having heard you explain what you were doing in this guy's house and this gun you're carrying around and all that, I'm going to have you for a little longer. But I want to keep open this option of Georgia Works. So it will be 5 years to serve 1 year, reduced time served on your entry into Georgia Works. In other words, you cannot be released until there's a transport order that would get you to Georgia Works, which is how it needs to be. You will go from the jail to Georgia Works. I don't want there to be a break where you're seeing if you could live with your mom's friend and you end up getting in an argument with your mom and you're on the streets and we don't see you again until something bad happens. You go straight to Georgia Works. We'll make sure they've got a bed for you. The other counts in your case, count 5, which is the misdemeanor involving marijuana, be 12 months to serve. That'll be reduced to time served also. And then count 6 will be 5 years to serve 1, reduced to time served, balance probated. That only leaves count 3, which has to be consecutive and has to be 5 years. I will make those years suspended. So your total sentence is 10. You're going to serve 1 year, but you're going to serve a little less than that because I will likely sign your final disposition in early October. And then that'll allow Mr. Franklin and his team to line up that bed in Georgia Works because they have accepted you. They're going to still want you there. And so it'll probably be a couple of weeks after that that you'd be transported to Georgia Works. Then you'll be on probation for 4 years. And the most important condition of your probation is that you complete the Georgia Works program. I'm going to add as another condition of your probation that you get your GED. Sounds like you got close because you got through 11th grade. Georgia Works will help you with that. After those 4 years of probation, there's that 5 years suspended. You don't report to a probation officer. You don't have to do anything other than stay out of trouble. That's how I'm going to structure your sentence. Do you have any questions about that, Mr. Baker?
No, sir.
Ms. Hall, did you have other conditions you wanted to see on the sentence?
No other conditions, Your Honor.
Okay. So, Mr. Baker, the sentence is a little different from what Mr. Franklin asked for in that I'm not signing it today. So you will do another month and a half or so before Georgia Works can come get you. It's not much different from what he asked for, but it's slightly more severe. I just think that's appropriate in light of how serious this guy. I don't know if there was a gun involved with your Florida cases, but I got to tell you, you're lucky that Mr. Brown was disciplined with a gun. Any number of homeowners could have put 3 in your chest when they opened that closet and saw you and you had a gun. You might have pulled the trigger first, and then you might have a dead homeowner, and then you're looking at murder charges. So we could have a dead Mr. Baker, we could have a dead Mr. Brown, and in either of those situations, we don't have the luxury of saying, we want to give you a chance to do something. But here you're getting a chance to do something. It sounds like the last few years of your life have not been very productive. You've been locked up, and we ought to see if you can be involved with society in a more productive way. And I'm kind of comfortable giving you that chance, but you need to understand that you and Georgia Works are sort of your best opportunity, and you need to play by their rules and make that be something that works, okay?
Yes, sir.
Do you want to talk with Mr. Franklin, or are you comfortable going forward?
Comfortable going forward.
All right, Mr. Franklin, anything you want to add?
Just for clarification purposes for me, I should instruct my social worker to look for a transport available in early October.
Yeah, I mean, you'll get, I don't know how it works. You have lots of cases, so your inbox may be filled with Odyssey notifications, but my intent is to sign the final disposition. Just looking at a calendar to make sure I'm not making a date up. So October 2 is a Friday, and I'll put a tickler to sign the final disposition in this case on that date. You'll get it anyway because it'll be e-file, but yes is the long answer to your question. You should have your team looking for transport no earlier than Monday, October 5, which would mean, of course, working with Georgia Works to see when they can get Mr. Baker in.
Yes, sir.
Okay. Last thing I think I need to take care of, Mr. Baker, if you were here in court, you would sign your indictment. I'm holding it here in my hands. But you're there. Do you authorize me to sign the indictment on your behalf?
Yes, sir.
Mr. Franklin?
Yes, sir.
And Ms. Hall?
Yes, Your Honor.
All right, and so I get all the notations on here. This is an Alford plea. And I'll put the stamp on it. It's a null pros to count 4. All right, Ms. Nelson, did I miss anything on this one?
Judge, I had to reboot. I got kicked off the Zoom meeting, so I'm kind of coming in at the tail end. So I have 10 years to serve 1. Enter and complete Georgia Works, 4 years on probation. We're going to hold the paperwork till October 2nd for transport.
Yeah, I'll work with you on that. I just want to make sure there weren't any other steps. I'll sign the indictment for everyone. I think that covers what we needed to cover. Ms. Hall, anything else for Mr. Baker?
Nothing else from the state, Your Honor.
All right, well, Mr. Baker, I hope this works out for you. And I hope you do what you can to make it so, all right?
Sure.
All right.
Judge, I need to get information from him also.
Right. Mr. Baker, Ms. Crawford's got a couple of questions for you.
Mr. Baker, hi, I'm Ms. Crawford from probation. I need to see if I can get an address from you and a contact person with their relationship and telephone number.
I have a phone number. Is there any way I can give you the address some other time? Right now, I don't have any addresses.
Okay, if you can just give me a contact person's name and their telephone number, I'll get the information from Mr. Franklin later.
Okay. Tiana Peterson. That's my sister. Number is 561 370-9653.
Okay, thank you.
Yeah.
Is that all you need, Ms. Crawford?
Yes, Judge, that's
Okay. All right. Mr. Forte, do you need a break or can we take care of Mr. Sampson?
Give me 1 minute, please.
Not a problem. We'll be back in a couple minutes. We'll get Mr. Sampson, and then I know Mr. Ford and Mr. Pinion and Ms. Snyder have been on this the whole time. We will get to your case. The jail is having to, because of these power issues, work through things in a slightly different order. So I'll be right back and we'll deal with Mr. Sampson.
Ms. Hall, are you there?
Were you asking me, Ms. Thompson?
No, I was asking Ms. Hall something. She's ignoring me.
I'm here.
Sorry.
If you need to go take a break, you can take a break. I just was wanting a breakdown of the sentence.
Give it to you. Hold on.
Okay, thanks.
As Mr. Frank.
So counts 1 and 2 were 5 serve 1, reduced to time served.
Wait, five serve 1. Okay. Mm-hmm.
Count 3 was 5 years consecutive but suspended.
Mm-hmm.
Count 4 is no prost.
Mm-hmm.
Count 5 is 12 months to serve, reduced to time served. And count 6 is 5 to serve 1, balance probated. The 1 year is reduced to time served as well.
Okay.
And then the conditions are get your GED and but all the things that are reduced to time served are reduced upon entry into Georgia Works.
Okay.
And it's a condition of the probation that he complete Georgia Works and get his GED.
Okay. Thank you, sir. Appreciate it.
Thank you. Ms. Nelson, did Nakia Sellers reach out to you at all yesterday?
No.
Okay. I'm going to send you an email. There's a person who, Tequila Williams, she had a case last year, a couple cases last year that was a virtual PTI agreement.
Mm-hmm.
I wasn't on it. It was something that was done in drug court,
Mm-hmm.
or behavioral health court rather, with Judge Reeder. And she completed what she believes are the terms of virtual PTI, but nobody has the agreement. And I know she was going to check in with you to see if maybe you might have an email or something that might have the terms of that agreement, because Odyssey reflects that a virtual PTI was agreed to that day, but I don't know who
If they
would
ever
have.
gave the paperwork.
Yeah.
Okay, yeah, if you send me the case number, I'll look into it and see if I have anything on email.
Okay, thank you.
Uh-huh.
There's Mr. Sampson. You still with us, Mr. Sampson?
Yes, sir. I'm still here.
Thank you for your patience. Mr. Forte, you ready to get back on the record with Mr. Sampson?
Yes, Judge.
Okay. Mr. Sampson, you remain under oath, so that means your answers to Ms. Hall's questions and mine need to be truthful and complete. We were in the middle of a misdemeanor plea. The state had reduced your felony charge of aggravated assault to simple assault. Then you had a criminal trespass charge. Hopefully, Ms. Hall, you remember where we were. Otherwise, we may have to put Mr. Forte on the spot to read back to you the last couple of questions you had asked Mr. Sampson.
I have it, Your Honor.
Great, thank you.
You're welcome. My show now.
It is your show now.
All right. Mr. Sampson, have you been arrested on these charges?
Yes, ma'am.
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
Yes, ma'am. No, ma'am. Ms. Hall, let just know that the fugitive squad came and picked me up on May the 15th, 2020.
Okay, Ms. Sampson. Has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
The maximum for both simple assault and criminal trespass is 12 months to serve. Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of, for aggravated assault, for simple assault, 12 months probation, and for criminal trespass, also 12 months probation, but for those sentences to run consecutively, meaning right after each other. So you'll be on a total of 2 years probation, but the court does not have to accept that recommendation. The court can sentence you to the maximum on each of these charges, which is the 12 months probation.
Yes, ma'am.
Okay. Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing or other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand this? Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would, and this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty, do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
How do you plead to the charges of simple assault and criminal trespass in indictment number 19 SC 173775?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
I don't understand.
Did you freely enter into this guilty plea conviction, understanding all the charges against you?
Oh, yes, ma'am, I understand.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Okay. Thank you, Mr. Sampson. Your Honor, the state is aware of 6 prior felony convictions by the defendant dating back to 2003. The 2 most recent convictions are both in Fulton County. The dispositions is February 27th of 2014, which is cocaine with intent. He is still on probation for that case. And then just a simple possession cocaine case, disposition date of November the 6th, 2014. The one that he is still remaining on probation is 14 SC 124457. And the most recent conviction is 14 SC 130160.
That's the simple possession, but you don't believe that that one is still open?
Correct.
Okay. All right. Any crimes of violence among the 6?
No, Your Honor. Oh, yes, Your Honor. I'm sorry. 2008, there was a conviction February the 12th for battery family violence. I am looking at the complaint room's criminal history summary. I'm assuming because it's on this particular summary that we do that it is a felony, but I can't confirm that at this moment.
Okay. And we don't know if it's the same Ms. Taylor who's the victim in this case.
Well, I'm gonna say, Your Honor, it's not, because I've talked to this victim and she met this victim around a couple months before this incident happened. This current incident that we're in court for.
Got it. Did you have any conditions? You may have said this and I missed it. Any conditions for probation? I understand it's 24 months is your recommendation.
No, Your Honor, I don't have any conviction. I'm sorry, additional conditions. And originally it was $175 for restitution for a TV that was damaged. I'm sorry, I didn't tell you the facts. I will, but okay. We're no longer asking for that restitution because that TV was apparently brand new and the victim was able to get it replaced under a warranty. So there's no more restitution for that. And from reading the victim's, not a victim impact statement, but just a statement that was given by the victim, interpreting that statement, seems like the defendant and the victim may be trying to move forward in some type of relationship. So I'm not asking for a stay away in this case.
Okay.
And because of all those details of
what I've learned. Ms. Taylor? Ms. Taylor has said, I'm okay with no stay away? Yes.
Okay. And we have received a whole page full of why and how much she loves him and stuff. So I'm just not gonna add that condition. But I will, give me 1 second, closing the criminal history and pulling up the facts. So Your Honor, had this case proceeded to trial, the state would have proven that on November the 29th, 2019 at 987 Ashby Grove Southwest, that's ASHBY, Grove, GROVE, Southwest Atlanta, Georgia in Fulton County. Officers responded to that location in reference to a dispute. When they arrived, they spoke with the victim, Ms. Taylor. She stated that her living boyfriend and her had gotten into a dispute, at which point the defendant repeatedly hit her with a closed fist in her face, and also damaged her TV that was at a value of $175. Since the defendant was arrested, he was not on scene when this happened. The victim was able to give the officers a description of what he was wearing, and he was arrested shortly after. And then the victim did positively identify him as the person who had assaulted her. After speaking with the victim a couple times this year, Your Honor, the story changed as to the events that happened that day, from what was told to the police, pretty much minimizing that it wasn't as bad as it was reported, and that even that day when the police were called, it was more so to understand why the defendant was acting the way he was and not to involve the state as in criminal charges being pursued. And she mentioned that she mentioned this to the police. We have been working, negotiating this case for a while now, and we feel like this is the best resolution due to all the circumstances involved here. So that is all from the state, Your Honor.
Okay. So Ms. Crawford, it sounds like there is at least one open case subject to supervision.
That's correct, Judge. It's the 14 SC 124457. He has 3 years, 5 months, and 19 days remaining.
Okay. Any cases from other counties that are open, or that's the only one you see that's open?
That's the only open case that he has.
Okay, thank you. Ms.
Oh,
Patel.
I'm sorry, Your Honor.
Yes,
I
ma'am.
will ask for no violent contact, Your Honor. Ms.
Okay.
Ms. Rolak is on it over there.
All right, don't be throwback. All right, Ms. Patel.
Thank you, Your Honor. Before you is Mr. Sampson, and speaking to him, he did say that they got into a verbal argument and that Ms. Taylor apparently bit his finger and she bit part of it off, and his fingernail, as a result, came off completely. And when she did that, he slapped her. So he does admit to slapping Ms. Taylor, which is why we do believe that a simple assault would be an appropriate charge in this case. They are trying to reconcile. Apparently, he has been on good behavior since this incident, and so we would ask that Your Honor accept this plea as negotiated. We would like to address the revocation if possible to do that today, and we would just request that he's been in for 97 days, that those days be revoked and that the balance be reinstated.
Okay. Well, you touched on something I was going to ask about, and you can answer it, Ms. Patel or Mr. Sampson can. He, for a little while, was hard to find. There was a bench warrant. May have been a bad address, or who knows. So I take it Mr. Sampson went into custody around the date of the incident, bonded out, and then returned to custody because of the bench warrant has been in, it looks like, since July-ish. Is that kind of right?
Your Honor, when I was looking into this, the only jailing attached to this case is this one. And I believe the case was directly indicted because they didn't locate him at the incident. So this is his first time addressing this case.
Okay. So
and his first time being arrested, I suppose, or in jail.
Okay. So Mr. Sampson, have you been in jail on this case just since July?
No, sir. I got arrested on this case back in May the 15th.
Okay. And where were you arrested? What city?
Atlanta, sir.
Okay. And you went to the county jail, and you've been in the county jail since May 15th?
Yeah, I've been here in Fulton County since May the 15th.
Okay. Were you not arrested back when the police got called in November of last year?
No, sir.
Okay, got it. So you've been in for a few months because eventually this case caught up to you.
Yes, sir.
All right, I think I got it. Ms. Rolak, did you have anything? I noticed you were helping Ms. Hall with this a little bit in terms of the conditions. Was there anything Ms. Taylor wanted me to hear, or are we good?
Judge, she did send a statement. It's not a victim impact statement. I gave it to Ms. Hall, who I imagine will put it on the record.
Okay.
Well,
she may have already referenced it. She did share with me that she's been reviewing information from Ms. Taylor, and I trust Ms. Hall's discretion there. I just wanted to make sure I didn't skip over if Ms. Taylor had something in particular she wanted to share. But the drift I'm getting is that Ms. Taylor is interested in trying to keep things going safely with Mr. Sampson.
That's correct, Judge.
Okay. All right. Mr. Sampson, do you work?
Yes, sir. I do landscaping.
All right. Were you working around the time you got arrested in May?
Yes, sir. Yes, sir.
Are you a freelancer or do you work with a crew?
Nah, I work with me and my father.
With who?
Me and my dad.
Oh, okay. All right. So he's still out there landscaping and he could probably use your help.
Yes, sir.
Do you have a place to stay when you get out?
Yes, sir, I do. Yes, I do.
With whom will you be living when you get out?
I've been living with a friend at 77 Joseph E. Louder Boulevard.
Okay. Is that an apartment or a house?
It's a house.
It's just 77 Joseph E. Lowry?
Yes, sir. That's the address.
Okay. But this friend is not Ms. Taylor.
No, sir. It's a friend I grew up with.
Okay. And why do you think you're gonna be able to stay there?
Because he approved of me staying there. We never had no problems, we growed up together.
Okay, all right. And will you be able to work with your dad again?
Yes, sir.
Okay. And tell me where you think the situation is now with Ms. Taylor. Is that a ongoing relationship? Is it done, or what's your thought?
Nah, we working it out. We still together.
Okay. How long have you known Ms. Taylor?
Almost 2 years.
How did you meet?
Met her through the neighborhood where I was at. Through
What
Ashby.
neighborhood was that?
Ashby. Joseph E. Lowry. They call it Joseph E. Lowry now.
Yeah, got renamed. Okay. Well, Mr. Sampson, I find there's a factual basis for your plea, these 2 misdemeanors. That it sounds like you did strike Ms. Taylor, not okay. And that you damaged the TV, also not okay. I also find that your plea is knowing and voluntary. Knowing means that you've understood all the things we've been talking about. Do you agree with that?
Yes, sir.
Do you have any questions for me or for Ms. Patel, your lawyer?
I was wondering, what they gonna do with the probation I'm on now?
We're gonna talk about that. So if you still have questions after I'm done talking about it, let me know, okay?
Yes, sir.
Any other questions?
No, sir.
All right. I also find that your plea is voluntary, which means no one's forced you to do this or threatened you in any way. Do you agree with that?
Yes, sir.
Okay. Then I'll accept your plea. I'm gonna follow the recommendation. I'm sentencing you to 12 months probation on count 1, which has been reduced to simple assault, and 12 months probation count 2. I will run those consecutively, one after the other, so it's a total of 24 months probation. A special condition of your probation is that you complete a family violence intervention program. And I'm also gonna have you submit to a drug and alcohol abuse evaluation. And if that professional decides you need any form of treatment, then that treatment will be part of your probation. They may say you're fine, there's no issue there, and then you don't need to worry about it. And finally, no violent contact with Ms. Taylor. So you two can still be around each other. It just needs to be no biting, no hitting, nothing like that, okay?
Yes, sir.
All right. Ms. Hall, anything else in connection with this sentence?
Nothing else from the state, Your Honor.
Okay. I'll talk about the revocation in a minute. Ms. Patel, any questions about the sentence in this case?
No, Your Honor.
All right. Mr. Sampson, in 14 SC 124457, that's your possession with intent to distribute cocaine case, I am going to, how long you been in?
About 94 days.
Since May.
97 as of today.
Okay. You said 95 or 75?
97.
97, okay. I'm going to revoke 90 days or 3 months, whichever is easier for probation to measure. In your old case, as a result of this new conviction, and then I'll reinstate the balance, and I will give you credit since May 15th. So all the time you've been in will be counted for your revocation. So you've already done 90 days. You know that, I know that now.
Yes, sir.
And then I'll reinstate the balance. You're going to be on probation in 2 cases, one a felony case and one a misdemeanor case.
Yes, sir.
Does anyone have any information for Mr. Sampson as to how he plugs in with misdemeanor probation? I'm hearing crickets.
Judge, I'll have to email that information to Ms. Patel to give to her client.
Okay, so Mr. Sampson, after you get out, Ms. Patel is going to give you some important information, and that is how you will meet with misdemeanor probation.
Yes, sir.
It's a different group, so you'll need to get together with them once you're released. Do you understand?
Yes, sir.
All right. I think that covers everything. Ms. Crawford, do you need any contact information for Mr. Sampson, or he's just being continued on probation?
He's gonna be continued on probation, but Mr. Reno will get this information from him.
Okay, sounds good. All right, Mr. Sampson, good luck. Go out there and landscape and be nice to Miss Taylor, all right?
Yes, sir. Thank you. Thank you, Mr. McBurney.
Did we sign, Judge? Did we all
Oh,
sign?
wait, one more thing. Don't go anywhere. Thank you, Ms. Hall. Your indictment, Mr. Sampson, if you were here in court, you would sign your indictment, which I'm holding right here.
Yes, sir.
There. Do you authorize me to sign your indictment on your behalf?
Yes, sir.
Ms. Patel
Yes, Your Honor.
and Ms. Hall?
Yes, Your Honor.
It's good because I already signed it. Need that authority. I'll get that stuff filed. Appreciate it. And that is it for Mr. Sampson.
Yes, sir. Thank you.
I now have position number 5.
All right, are you Mr. Williams?
Yes, sir.
Hey, Mr. Williams, we've got your lawyer on the phone, Mr. Ford. He has been patiently waiting for a couple hours now. We've had to move in a different way through the calendar because of some power outages there. Williams, you got some pretty serious charges here. You are on the calendar for what we call a final plea, just to see if the case is worked out or not. I guess I'll start with Mr. Pinion. Mr. Pinion, are we in the right spot? Final plea, you've provided all the discovery to Mr. Ford and made an offer?
Well, Your Honor, there is some discovery that initially wasn't turned over that I have found, and it's digital media that I do have. Now I do have it, and it is ready. However, I had been looking at Odyssey, and I noticed that Mr. Ford had filed a motion to withdraw, and the defendant had also filed a letter, which I read, stating he wanted a new attorney. So I have not discussed the case with Mr. Ford lately.
Well, this is a good time for us to work through all that. I have now pulled it up in Odyssey as well. So let's start with Mr. Ford. Mr. Ford, it looks like in July 16th, you filed a motion to withdraw. Let's see what it says. You believe that Mr. Williams may qualify for court-appointed representation, and that Mr. Williams consents to that. We'll find out in a minute from him. But why don't you bring us up to speed? You're muted, so you need to unmute. Thank you. And Mr. Forte, you're good right now. You don't need to worry about this. Mr. Ford. Yeah, we can't hear you. Whoa. You want to try dialing back in?
The microphone shows it's still actually mute on his end.
Well, he's gone back and forth. He's muted, unmuted, and it hasn't worked either way. All right, he dropped, so he's going to dial back in. Mr. Williams, you're on mute, but I do need to hear from you too. All right, I'm gonna wait till Mr. Ford dials back in. Are you aware though that he may be coming off the case and you may be looking for another lawyer, or is this news to you?
He was supposed to withdraw December with Ms. Rebecca, my last turn judge.
Okay, all right, we'll stop. I want him to be on the line. I just wanted to make sure you guys were aligned on this.
I also want to make the court aware after this position, I have to go get position number 8. So it might be 3 to 4 minutes and I'll be back.
Understood, thank you.
I'll go right out of that some point.
Ms. Nelson, can you reach out to Mr. Ford to see if he is gonna try again or if he just gave up?
I will.
Thank you.
While we wait, I can go get position number 8 if the court would like.
Okay, yeah, why don't we do that? When Mr. Ford gets back on, we have Ms. Snyder here, so if we want to flip flop, that's fine. Thank you for suggesting that. Ms. Snyder, can we test your audio?
Yes, sir. I'm here.
Great, excellent. All right. So while they're getting Mr. Tolbert, what is it, Mr. Opinion, that you just now discovered? I didn't realize how old this case is, but it was indicted in early 2019. So we're past the 18-month mark. What's the digital discovery?
Well, Your Honor, it's not anything that was newly discovered. I inherited this case this year, and going through it and the discovery that was filed, and then speaking with defense counsel, there was digital media filed, but we both saw that there were certain statements that were taken by the officer, and there are a number of videos, but it seemed like the detective was mentioning videos that I didn't see on the flash drive. And so I communicated with her, and we've gone back and forth about that. And I was sent a OneDrive, I guess, data to download, and that wasn't successful, but we got another copy of the file, and I do see some videos that were not on the digital media that was served. And that was supposed to be the whole case file, but it unfortunately was not. All the information is mentioned in the incident report, and just as I suspected, there was recordings that corroborate that. And I have a flash drive of that now in my office.
How do we get that to Ms. Snyder and mystery lawyer for the other defendant?
Yes, I will make a copy of that myself and have it available tomorrow.
Okay.
It can be picked up on the 3rd floor.
Okay. Is the nature of the material significant enough that we ought not to have the final plea discussion? At least it sounds like, Ms. Snyder, are you staying on the case as far as you know?
Yes, sir. I'm staying on it. Mr. Williams would go back to the public defender's office because they had him at first appearance before he hired Mr. Ford.
Sure. But is the nature of the missing videos such, Mr. Pinion, that we ought to give the defense a little longer before we do final plea? Final plea, at least the way I do it, in a murder case, is in some way a formality, because it's usually the defendant saying, I choose not to plead to life. And I get that. And then we move on to trial. Every once in a while, it's going to be we've sorted out, and it's 20 years on a voluntary. And so I'm just asking, we could delay all this. We may need to because of counsel for co-defendant, but we also could say, let's get this on a trial calendar whenever we next have a trial calendar, because between now and then that discovery will be provided. And by the way, it's not suppressible discovery. It's not a statement of Mr. Tolbert, whatever it may be. Does that make sense?
Yes, Your Honor, this discovery, as far as I can tell, doesn't change anything. It's just corroborating. However, I will say that just to give you background, this case involved a victim walking down the road near Georgia Tech, and a vehicle stopped and robbed the victim, took his backpack, shot and killed him, and then drove away. There was a witness that saw one person do this shooting, but there was another individual with him. And from our evidence, the individual that did not do the shooting would be Mr. Tolbert. And I had discussed that with defense counsel, that it's quite possible we could reach a resolution. Mr. Tolbert did give a statement that implicated the co-defendant, Mr. Williams, and that we may, if I am given permission to, I would want to use Mr. Tolbert at the trial of Mr. Williams. So it is quite possible.
Communication working right now.
I'm sorry, I didn't catch all that.
How do you get permission for things these days?
Well, that's why I was suggesting a final plea date, possibly with a 21.
Right, we can't wait quite that long. But it sounds like, one, we ought to get these materials to the lawyers. Two, we ought to figure out who all the lawyers are going to be. And then three, you may need to do a little work figuring out, and I'm talking to you, Mr. Pinion, figuring out how do you get the green light to resolve one of your cases in this post-election era?
Yes, Your Honor, that plus COVID complicates the issue.
Well, yes and no. Getting digital discovery to the lawyers, we can work through, and you work in the chain of command to figure out green light, not green light. I don't know that COVID makes that a whole lot more complicated. I want to rely on the pandemic when we ought to rely on it to slow things down, but I don't want to abuse it so that it starts to mean nothing to folks. So,
correct.
Let me hear from Mr. Ford. Well, let's first find out. I know we've been bouncing around. Can we hear you, Mr. Ford? Nope. If you want to do audio only and just call in, we could try that. I don't know that what we're going to be doing today will require you to see. There we go. You're going to write it. Okay. So let's figure out, you don't have to do anything right now. 7 South, who do we have? Do we have Williams or Tolbert right now?
Yeah, Tolbert.
All right, there he is. How you doing, Mr. Tolbert?
I'm doing fine.
I'm Judge McBurney. Your lawyer is there, Ms. Snyder, and the prosecutor is there, Mr. Pinion. And we're going to talk a little bit about your case today to get an update about what we can do to move it along. As you've probably figured out, we're not having a lot of trials these days, but that doesn't mean we can't make progress with your case. So Mr. Pinion, as I understand it, there's discovery that you believed had been provided, but maybe wasn't included in the thumb drive that your predecessor provided. And you will make that available to Ms. Snyder as early as tomorrow or pick up on the 3rd floor?
Yes, Your Honor. And yes, I went and reviewed the detective's file because we had everything supposedly, but in the digital transfer to our office, it became clear that there was some digital media that we did not receive. And it is not part of the discovery. So I do have that now. I've been looking at it today as court has been proceeding, and I don't see anything that changes anything. It's just confirmation that what the detective wrote in her report. She had interviewed a number of witnesses and stated they said things, and it does appear to corroborate what she wrote in her report.
That they really said those things.
Yes, that the witnesses said that. And again, this defendant did give a statement to the police admitting his involvement. I mean, his presence at the scene and being in this vehicle. He says it was the co-defendant that did it, and then they left. That the co-defendant saw the victim and just said, and when it had an issue with him, and then shot him, and then they left in the vehicle. So he would be very useful in the trial of the co-defendant, and I certainly do want to get the actual gunman. So I am hopeful that we'll be able to reach a resolution so that Mr. Tolbert is able to testify.
We don't need to work that out in this setting. I just wanted to understand where the state was. You believe, Mr. Pinion, that what you will make available to Ms. Snyder as early as tomorrow would be the rest of your case file?
Yes, Your Honor. There was there were shell casings at the scene, and those had been sent to the GBI for ballistics testing and possible touch DNA. And I have asked for that to be done, but it has not been completed yet.
Okay, well,
and that's basically it.
All right, if the calendar smiles upon you and you get it done, but that's not going to be a reason to slow things down, in particular for Mr. Tolbert's case. Ms. Snyder, how much time would you want to review the materials that you'll be getting in the next few days before you'd be in a position to negotiate on behalf of Mr. Tolbert?
I'm not sure. I'm having difficulty making my computer cooperate with evidence reviewer. Our IT people tried to fix it remotely, but couldn't do it. He said he's got to come do something physically to my computer. And he's supposed to come in later this week. So I know I won't be able to look at it until next week or the earliest.
Okay. Mr. Pinion, what is your best guess as to when you'd be able to engage with someone about a resolution to Mr. Tolbert's case? Because I heard you said that there might be the possibility that it could be worked out. And you might believe that's very much the right thing to do, but you need to get that blessed. How much time would you need for the blessing process to work?
Well, I would, that's really a educated guess on my part right at the moment.
Or an uneducated guess. So here's what I'm going to do. I'm going to have this put back down for final plea for Mr. Tolbert in a few weeks. Ms. Nelson can figure out what makes the most sense based on the schedule, but it would be a couple or more weeks out. By that time, Ms. Snyder can figure out how to get her computer working. She'll have the additional discovery, and you'll figure out, Mr. Pinion, if there's a way to get an offer blessed. If there's not, then the offer would be to plead to the indictment, and Mr. Tolbert might say, I would just soon have my case moved to a trial calendar. But it's not going to compromise anything other than we move the case along. But I don't want defendants to be stalled out because it's not clear to well-meaning prosecutors how to get resolutions approved. Does that work for you, Ms. Snyder?
Yes, sir.
Mr. Pinion?
Yes, Your Honor.
All right. Mr. Tolbert, do you have any questions for me right now?
I have questions like, you know, a couple weeks ago, I had got assaulted by an officer and I got hit in the face with a handcuff and it shot at the left side of my face. And I was just wondering, out of the situation, I was wondering when can I maybe get a bond, because I've been sitting here 19 months being patient. And
so that's a great question. And I'm just cutting you off because I don't want you to get too much into the substance of your situation right here. You and Ms. Snyder should talk about that. She will give you her advice as to whether a bond hearing would be productive or not, or if in fact, what you ought to be thinking about is, how do I resolve my case?
I am thinking about these same things, but at the same time, I still have family. I still have people I have to look after. I still have a child that was just born, and now he's 1 year old. I have never seen him. I still want to go out there and work. And try
Anthony, let me stop you. We'll talk about a bond.
It's just I've been in here 19 months, and I feel like it's fair. I've been patient. I even take house arrest. And
then we gotta have a conversation about it, and that may involve getting you over here or getting the right people on the Zoom session. We don't have all the right people because today we weren't gonna talk about bond, but that doesn't mean we can't do that soon. Ms. Snyder's gonna be getting the rest of the discovery in your case tomorrow or the next day, and then she's gonna wanna talk to you about that, and we'll see where that takes us, okay?
Hey, Ms. Snyder, when are you available to come see me?
We'll talk.
Because we have a situation that had just happened, and I need to speak to you.
Okay.
All right, she'll track you down, all right? Thank you, Mr. Tolbert.
Give me a minute and I'll be back with the other guy.
Okay. Mr. Ford, can you hear me?
I can. Can you hear me?
Yes, sir. That's perfect. They're going to get Mr. Williams back, and we're going to limit the conversation solely to representation. So I think it's fine that what we see is the T rather than you sitting in your fancy sports car. So we'll get Mr. Williams on the screen, and then we can talk about how this is going to work. I didn't realize you had filed the motion to withdraw. That ought to have been the topic du jour for this case.
Roger that.
Mr. Ford, are you still with us?
I am, Your Honor.
Okay, it's just a different, I see where you are. It sounds like your car has actually taken off. Are you flying now?
Well, I've chosen to drive. That's okay. Now that I'm just listening.
No, that's fine.
I've left my Kroger's parking lot perch.
Ms. Snyder,
Yes, sir.
how has August in your other courtroom been?
A lot.
Are you guys moving cases or are you just having to show up?
It's mostly been case management, plea and arraignment. We have our first final plea on Thursday.
Okay. And is it just August or is it that's the way it's going to be for the foreseeable future?
It sounds like that's the way it's gonna be. We've had calendars pretty much every Tuesday, Wednesday, and Thursday the whole month of August.
Okay. Well, I hope you're enjoying it.
It's keeping me busy.
Has joined us. How you doing, Mr. Williams?
Good to you.
I'm okay. So Mr. Ford is on the call. He is the little phone icon there that ends in 284. So he can hear us. He just can't see what's going on. But now the three of us can talk about representation. So Mr. Ford has filed a motion to withdraw, saying that he thinks he should come off the case. Do you agree with that, Mr. Williams?
Yeah, I actually requested in December.
Okay. And Mr. Ford is an attorney that you would have retained. You or someone in your family would have paid him some money, which would say to me, you don't qualify for representation by the public defender's office, although you originally had a public defender. Tell me what your plan is. If I release Mr. Ford from the case, are you planning on hiring someone else? Or are you planning on having, I don't know if it would be Mr. Franklin or Ms. Patel, those are the two, it would be Mr. Franklin. Are you planning on having Mr. Franklin represent you?
I was thinking of having Mr. Franklin.
Okay. Mr. Franklin, does your office need to do any due diligence to make sure that Mr. Williams qualifies, or is it kind of self-evident because he's been in jail for 18 months?
I think it's essentially self-evidence, but I will go to the jail and do an interview with him. He's called me on the phone within the last month. I think that may be how he ended up on this calendar.
Okay.
And I just needed to have Mr. Ford officially off the case before we're able to get the ball rolling in that regard. So I can't imagine he won't qualify after having been in custody this long.
Okay. Well, I'll enter an order granting Mr. Ford's motion to withdraw. which will leave Mr. Williams without a lawyer. And that order will direct the Public Defender's Office to interview Mr. Williams to see if he qualifies. Assuming he does, then Mr. Franklin will be representing you, Mr. Williams. And we'll need to make sure Mr. Ford gets his case filed with Mr. Franklin. And then it sounds like there's a little bit of information that Mr. Pinion, who's the prosecutor, will be getting to Mr. Franklin. That Mr. Franklin should have all the evidence. I'll need to give Mr. Franklin a little bit of time to look through the case file so he can decide if there are any motions he wants to file. I know, Mr. Williams, you filed some motions, but anything you file while you've got a lawyer, I have to disregard. You speak through your lawyer. So you and Mr. Franklin will talk, and he may tell you, no, I don't want to file X or Y or Z, and here's why. Or he may say, yeah, I'm going to file it. But I'll give him time to do that. They will not be late motions because he's new to the case. Does that make sense?
Yeah, I was actually familiar with the file the motion thing, but I did it anyway because I was having a problem with my.
All right, that's often what defendants do. They say, Judge, I know that, but I'm doing it anyway. We'll have Mr. Franklin come meet with you, and assuming he can represent you, then he'll take over from there. Do you have any questions about that, Mr. Williams?
No, that sounds about right.
Okay. Mr. Ford, any questions about that?
No, sir.
All right. Mr. Franklin?
No, Judge, I'll reach out to Mr. Ford and figure out when I can get a copy of what he has.
All right. Sounds like a plan. I think that's everyone. I think we've gone through the calendar. Do you have anything else, Mr. Franklin?
No, sir.
Mr. Pinion?
No, Your Honor.
All right. Ms. Snyder?
No, sir.
Ms. Hall? Did you already take your trip, Ms. Hall, or is that still to happen? Was it a good trip? I can't hear you, but you smiled, so I assume it was a good trip.
I'm sorry. I didn't know I was on mute. Yes, I took the trip already. And yes, it was a good trip.
All right, well, we're glad to have you back.
Thank you.
And Ms. Patel, anything else?
No, Your Honor.
Okay, I think that's it. Let's look at the calendar together. Haven't had you guys in court all that much recently for discussions. Let's see. That's it for this week. One afternoon. Next week, we've got a little bit more. We've got a suppression motion, Ms. Patel, Monday morning. Is that something where your client is on bond and so everyone's showing up, or what's your understanding?
He is out on bond, Your Honor, and he does intend to show up. The only issue is that I still don't have the recorded interview of the complaining witness. So Ms. Hall and I are going to meet later today. Or not Ms. Hall, Ms. Hodge and I are going to try to meet later today. And I'm hopeful that she's able to figure something out so that before the hearing I have a copy of that, because the lineup was recorded in this interview as well.
Okay. Do you have a copy of it and you just can't play it, or Ms. Hodge has never given it to you?
So she gave me what may or may not be it. It's something that won't open and can't play. And the issue is that what she has in her file that her admin had copied is not even related to the case at all. So she doesn't have a copy in her own file of this interview. So we're hoping that whatever I was given, there's someone in IT at the district attorney's office can figure out if that has anything on it.
Okay. Hope that works out. All right. I think that's it. Thank you, everyone. Thank you, Jail. I know you guys had some issues out there. Appreciate your help.